SJC-11341, Commonwealth v. Garret, Jackson.
Thank you. Ms. O'Brien.
Thank you, Your Honor. May it please the court. Mr. Jackson's first two arguments in his brief concern the trial prosecutor's peremptory challenges to two different jurors. Defense counsel objected based on Commonwealth versus Soares. He objected on the basis that the challenges were improperly directed to jurors of color. I'll begin with the objection, the peremptory challenge rather, to juror 115. The judge in the case described juror 115 as Hispanic. He also described her as being neutral in color, and at another point described her as being of color. The judge questioned whether being of color was a sufficient category for an objection under Commonwealth versus Soares. In any case, the judge found that no pattern had been shown, and he allowed the challenge. I approached this in my opening brief by looking at it as improper challenges to Hispanic jurors. And I'd suggest that that's a strong argument in and of itself. This is a case where the judge recognized that there were few jurors of color in the panel to which juror 115 belonged. There were three Hispanic jurors who had been challenged. So I certainly at that point, there was reason for the judge to inquire under the light burden that a defense counsel had to meet in such a situation. And you also had an additional strength to that argument was the fact that the judge mistakenly believed that Hispanic jurors were not a protected group under Batson and Soares, which of course they are. Then in response to the prosecutor's argument that the of color objection wasn't sufficient or didn't sufficiently describe or preserve the objection, defense counsel's objection, I went back and looked more closely, trying to discern exactly what the judge understood that objection to mean. And the judge actually, even during the conversations regarding juror 115, the judge made it pretty clear that he understood that what defense counsel was referring to was not only Black people, but also Hispanic people who could be Black. And as to the three jurors who were at issue at that point in time, the judge expressed doubts. He said he didn't know whether or not any of the three were Black. He said, we just can't know. So he was expressing doubts. And then when we get to juror 151, about 90 pages later, the judge makes it even clearer that he understood what was meant by the term of color. He stated, and of course, I want to be sure to mention that the judge is actually looking at the jurors who are being challenged. He's there looking at the jurors when there are objections. So the two terms the judge uses to describe the people he believes defense counsel to be referring to are, quote, Black or Hispanic, which could be Black. And then farther down on that same page, page 151 of volume 2, he refers to people who are African-American, quote, African-American, or perhaps have African blood. So the judge understood.
Can I interrupt you for a minute here?
Certainly.
You know, I understand with whatever I think the judge was approaching this was trying to make sure he was staying within the protected class categories and trying to make sure he was dealing with protected classes. And there was some reference to non-white jurors and some people who couldn't be properly categorized. But putting all that aside, when the judge ultimately did come to make a decision on this, what factors was he permitted to look at?
Well, he was permitted to, there are a number of factors. Of course, the court has held that there are quite a number of factors that the court can look at. But what he did look at, and what he certainly knew at the time that he disallowed this challenge, I'm going to suggest that he knew at least three things. First, he knew that by that point in time, the prosecutor had made challenges to one person who was clearly Black, and 3 who, in the judge's eyes, he wasn't certain, but they could be Black. So the judge knew that first. Second, he knew another consideration that the trial judges had to take into consideration are whether the challenges are directed to persons of the same race as the defendant. And of course, the judge knew that the defendant in this case, Mr. Jackson, is a Black man. And third, as the judge stated at I believe it's page 150, that he had noticed that there were a lesser, quote, a lesser amount than I normally see of people of color in that particular panel that juror 115 was a part of. So there are at least those 3 factors that the court has said should be considered that the judge knew of here. I'm sorry, Your Honor.
We've got, there's a dispute between you and the prosecutor about what the percentage of we're focused on Hispanic, right? You keep sort of merging color and Hispanic, but at this point, to be clear, we're dealing with the challenge on that was improperly discharged as an Hispanic juror, right? That's where we're focused now, on this juror.
Actually, I'm asking the court to focus on both, Your Honor. The total of 4, and I've addressed this in my reply brief. So I'm certainly asking the court to consider because defense counsel actually made the argument that this was 4 out of 6 persons of color who had been challenged. That was trial counsel's argument. I did argue that it was 3, that it was 3 out of 5, counting only the Hispanic jurors in my opening brief, but then pointed out that the judge understood the objection using the term of color to include the Black juror and the 3 Hispanic jurors who could be Black.
Aren't you sort of, by glomming things together, aren't you making the same error that we've counseled against? Particularly, she's not a Black Hispanic, right? Or is she? I'm confused of what we're analyzing, because my understanding is, having read your brief pretty carefully, you're focused on the fact that she's Hispanic and she shouldn't have been knocked off as an Hispanic. Right?
I did focus on that, and I'm certainly not asking the court to disregard that argument, which I'd suggest is a strong argument.
So
but after seeing...
On the Hispanic point, there's a debate between you and Mr. Armstrong about whether it's a comparison of 60 versus 50 or 60% versus a smaller number.
Yes.
How do you get to the smaller number? Why is Mr. Armstrong wrong on that point?
I believe what happened with Mr. Armstrong's calculation is that he did not take into consideration that the prosecutor had the first opportunity in each case to challenge. So for each of the jurors who were not excused by the judge, the prosecutor had the first opportunity to challenge. So that was what made the difference in so the proportion that I came up with, which was approximately 60% or more than 60% being challenged. And the prosecutor came up with a calculation that was approximately half of that by omitting the fact that the trial prosecutor had in each instance, the trial prosecutor had the first opportunity to challenge. So what I was looking at was the actual opportunity to challenge versus actual challenges.
Okay, so putting the statistic aside, so another factor we look at is the defendant or the victim Hispanic? In this case, neither the defendant or the victim is Hispanic, right?
Neither was Hispanic, both were Black.
Okay, and then there are the other factors also. 2 other Hispanic women have been seated, correct? That's
Yes.
another factor to consider. So it doesn't seem like any of the Lopez factors, or as the other cases we talk about, we're not into the area of concern. So isn't the judge right to find there's no pattern here?
No, the judge was wrong to find, if the burden is light, and the court has repeatedly said that it is light, the fact that there are 3 Hispanic jurors challenged, the fact that the judge has said there are a few jurors of color, and he's counting clearly counting the Hispanic jurors in that category as being of color. The fact that there are a few there, that was enough for the judge to require inquiry. And I do hope, even though I did this in response to the prosecutor's argument that the objection under the of color phrase was not sufficient or was not clear enough, I am asking the court not to disregard that, because the more I looked at it, the more clear it became to me that the judge knew exactly what defense counsel was saying. And when you look at that, you have a Black person and 3 people who could be Black, according to the judge's own statements, a Black person and 3 people who could be Black being challenged in a case where you have a Black defendant. And surely that was enough to make it necessary that the judge inquire further. Given the standard, again, which the court has even as recently as Sanchez reiterated. So I'll proceed to the second argument, unless there are more questions about that. The second juror who was challenged was, according to the judge, was Black. She was Hispanic, but the judge stated that she was Black. At that point, the judge said that there had been 5 challenges to jurors who were Black or could be Black under the phrasing that I quoted just a couple of minutes ago. 14 jurors had been seated at that point, so there were few additional opportunities to seat persons of color, which obviously was a priority to defense counsel in this case. So the judge at that point, and this is only with one more challenge in this category of people of color, the judge did say that he saw a pattern. He actually saw this as a close call, which I'd suggest is remarkable. But he did say that he thought it was a close call, but he did ask for an explanation. And the prosecutor's explanation was to say that the juror had both of her sons arrested and prosecuted, he said. And the judge, the judge actually didn't, the judge went on to allow the challenge, found that to be a sufficient reason to challenge the juror. And the difficulty with that is that it's exaggerated. The prosecutor found that, the judge found that reason to be adequate and genuine, but it was neither. It was neither adequate nor genuine. It was not adequate because it was exaggerated. The judge specifically—
How is it exaggerated? I don't understand the exaggeration.
The judge specifically asked this juror if her sons had been prosecuted, and she said no, they had not. The charges had been thrown out. Neither of these sons had been prosecuted as the prosecutor claimed. They had been arrested, the younger son for being in a stolen car, the older son for having some marijuana.
And this is the juror who also was related through her mother to one of the detectives?
She was related to Detective Thornton, who she stated she did not know. And the judge actually disregarded that reasoning. And I'd ask you to actually look at the testimony.
I don't understand when you say he disregarded that reading. What do you mean?
The judge made extensive findings. The judge, if you look at this, the judge did not immediately make his findings that regarding the validity of the challenge. The judge waited until he had examined another juror. The judge waited until after the lunch had finished. Then he came back on and said, well, I'd better elaborate on my reasons for allowing that. And he never mentioned he only mentioned this, this exaggerated reason that the jurors' sons had supposedly been arrested and prosecuted, which was absolutely not true, not adequate, or genuine. He didn't say anything about the knowledge of Detective Thornton, and I'd suggest there's good reason for that. First, the juror said she barely knew Thornton. The prosecutor was saying at that time that he didn't even know whether he was going to call Thornton. And Thornton, if you look at his testimony, you can see why the prosecutor would be uncertain, because there was nothing critical about Detective Thornton's testimony. The case did not depend in any way on Detective Thornton's testimony. He testified that he was at the scene. He described the scene. There were any number of other detectives who could have provided that information. He said that he was there for the interview of Judy Brown, but no information about what she said. I think that it would even be reasonable to question why he was even called. Was it possibly to justify this or to back up this peremptory challenge of the Black juror number 13? So, so I'd ask if there are further questions regarding that.
No.
I'll proceed then to the third argument. This is regarding the gruesome photograph that was introduced into evidence. And I certainly think I have to acknowledge that there was a question here whether this was adequately preserved by an objection. It was a bit of a wishy-washy objection there. And there was no objection when the evidence actually came in. However, even if this is looked at under the substantial likelihood standard, under the substantial likelihood of a miscarriage of justice standard, nevertheless, there should be a new trial based on this error. The court has very clearly stated in the Bastarash case that photographs of a victim's body taken after it has been altered at autopsy should not be offered unless they are relevant, should not be admitted unless they are relevant. There was no relevance to this extraordinarily gruesome photograph, which frankly I could hardly look at myself. I considered whether to include the color version, which I actually couldn't bring myself to do. It was horrific enough. So
it's clearly relevant, right? Because it shows the trajectory of the bullet, which was an issue raised by the defense, right? It may be unduly prejudicial, but it's clearly relevant, right?
It's not relevant. There was no contested issue about the trajectory. Both sides agreed that the victim was shot in the back of the head and the bullet came out the front of his head through the eye. There was no contest about that issue whatsoever, Your Honor. And as you're considering that, it was absolutely uncontested. And as you're considering that,
Defense counsel didn't focus at all on the trajectory and what it signified, nothing?
he had a question about the trajectory, but Your Honor, it was not relevant to anything.
So the defense counsel was asking irrelevant questions? I'm confused.
He asked an irrelevant question. He actually asked very few questions of the medical examiner, but he did throw in a question. Maybe someone could, if someone suggested some relevance to me, maybe the prosecutor can suggest what the relevance was. I saw no relevance at all. So under the substantial likelihood, I'd ask the court to consider the strength of this case, where there was no evidence, no physical evidence to connect the defendant to the scene. There was heavy reliance on the 4 civilian witnesses who were all not only addicts, not only crack cocaine addicts, but were deep in the throes of their crack cocaine addiction. At the time they made they either heard the statements they said they heard or saw the defendant at or near the scene. And in addition to that, 3 of them said, or 2 of them spoke to each other shortly after the shooting, Ms. Ross said she spoke to Ms. Brown very shortly after the shooting about what Ms. Brown saw. Ms. Brown said she spoke to Ms. Ruspis about what she saw, and yet neither one of them came forward and pointed the finger at Mr. Jackson in any way for months. So I'd ask the court to consider that in determining whether there's a substantial likelihood of a miscarriage of justice here.
Thank you, Ms. O'Brien.
Thank you, Your Honors.
Mr. Armstrong.
Good morning, Your Honors. May it please the court, Houston Armstrong on behalf of the Commonwealth. I would like to acknowledge members of the victim's family who are watching this argument remotely, as well as the trial prosecutors, Edmund Zabin and Elizabeth Martino. I would also like this court to take note of the extraordinarily long time it has taken this appeal to be heard. The defendant's appeal was entered in this court on November 3rd, 2012. Now 9 years, 9 months, and 16 days later, and 5 appellate attorneys have passed, and the defendant's case is now just being argued. This is unfair for the family and is forcing them to relive some of their darkest days, now 10 years later. This court should affirm the defendant's conviction for first-degree murder and decline to grant relief under 33E for the execution-style killing of Tommy Speed on February 11th, 2009, because there is nothing in the record which casts any doubt on the validity of the defendant's convictions. The facts of this case showed that the defendant acted with a plan to eliminate his competition in his neighborhood. He acted with malice in his heart and a gun in his hand. He carried out the assassination of Tommy Speed.
Mr. Armstrong, can we focus on the jury issues? Because
Certainly. So turning to the first juror issue, Juror 115, the trial judge did not abuse his discretion in declining to find a pattern because he, as was discussed during my sister's argument, explicitly discussed a number of the Lopez factors. And in addition, there were a number of factors that were readily apparent to him. So specifically, he spoke about the challenges that the Commonwealth had exercised. He spoke about the composition of the seated jury. The race of the victim and the defendant were readily apparent to him. And there was also a objective group neutral explanation that was readily apparent to him as well. And he didn't overly focus on one of those factors, and by doing that, he did not abuse his discretion in declining to find a pattern. And as an initial matter, I would also point out that the defendant's objection at the time, being a person of color, is an issue that's previously been raised and found by this court to not be a proper objection. And that's specifically in the Lopez case, which was from 2018. And even though that is 7 years after this present trial, the Lopez case is citing back to Soares, and the language of Soares is specifically talking about particularly defined groups in the community. So never has this court held that that persons of color is a sufficient objection. It always has to be targeted towards a specific group. So that's to my first point in my brief that
Mr. Armstrong, could you address the statistical disparity issue? Because you've got a 50% number and your sister has a different number, and I had trouble following that difference.
Sure. So my calculations first are the challenge of Hispanic jurors, and that the Commonwealth challenged 3 Hispanic jurors, which includes this juror 115. So that's and then the 2 other jurors who were not challenged were seated. So 3 out of 5 is 60%. So there's the Commonwealth challenged Hispanic jurors at a 60% rate. My comparison number is based on non-Hispanic jurors. And the reason I use non-Hispanic jurors, I was going off of this court's decision in Jones, where it acknowledges comparing African-American potential jurors to non-African-American jurors. So my calculation comes from when you subtract the 5 Hispanic jurors from the number of Commonwealth challenges to the number of seated jurors, there's 22 jurors remaining. Of those 22 jurors, the Commonwealth struck 11 of them, which is a 50% strike rate for non-Hispanic jurors.
Mhm.
And while the numbers in some case can demonstrate a pattern or establish the defendant's burden of a prima facie showing, that's not the case here. These numbers are very, very close and show that the Commonwealth wasn't challenging Hispanics at an overly high rate.
On the second juror, I don't know if Justice Seibert has questions on the first juror. No. On the second juror, how do we have the judge, the prosecutor focuses on three different things, and that, or at least three different things, and the judge then says those are adequate and genuine. But then he decides to make further, more specific findings that don't reference the detectives being his cousin. Is that fair game for us as a reason or not, given that the judge doesn't bring it up the second time?
You're referencing the prosecutor's third reason, the
cousin, that the detective is the cousin of
the potential juror.
yeah. Mhm.
So my first response is, yes, you consider all three of the prosecutor's proffered reasons, because at the judge's initial response, he says, I find all of these reasons to be adequate and genuine. And just because he comes back after the lunch recess and expands on one of those potential reasons doesn't detract from the other ones. So, and even considering when the further explanation, he doesn't address the age of the potential juror's sons being close in age to the defendant or the family relationship. Those do not detract from the adequacy and genuineness of the prosecutor's reasons, or even more, it doesn't detract from the judge's earlier statement saying, I find all of those reasons to be adequate and genuine.
The issue of the children's prior encounters with the law, is there consistency of treatment of others by the prosecution on that point?
Yes, Your Honor, and that goes to my initial point for Juror 115 about being an objective group neutral reason for the strike of Juror 115. There were, prior to Juror 115, there were 5 peremptory challenges for potential jurors who had involvement with the criminal justice system. Specifically, that's Juror number 26, Juror number 38, Juror number 42, Juror number 51, and Juror number 55. And then by the time we get to Juror number 13, that would be 6 potential jurors, because Juror number 115 had pled guilty to disturbing the peace out of the Dorchester Division of the Boston Municipal Court and received a 1-year probationary sentence. So that
Were there any people with prior experience that weren't objected to?
who were sat on the jury?
Yeah.
Not to my recollection, Your Honor, and I double checked that, but I did not find, not to my recollection, no.
And although not raised in this brief, we've got to do 33E review. There's this whole issue with juror number 35. Was that person who was the former drug enforcement officer, was he seated?
He was, Your Honor. He was the final seat number 16. But
and so, and I guess the defense is out of peremptories at that point. Is that right? I can't remember. Is that why?
that's correct, Your Honor.
All right. Thank you. That's all I have on that.
And I'm not remembering specifically, Your Honor, but I actually believe juror number 35 did not take part in the deliberations.
Oh, he did not? Okay.
That's my recollection, Your Honor, but I can't point you to a specific spot where that is.
Okay.
So if there's no further questions in regards to juror number 13, I'll move on briefly to the autopsy photograph. And this photograph was properly admitted, and the trial judge did not abuse his discretion in allowing it in. First off, this photograph was not objected to by the defense attorney. The defense attorney did make He did have a reaction when he saw the picture, but he did not object to it at the sidebar, nor did he object to it coming in. So this court should review for whether that photograph created a substantial likelihood of a miscarriage of justice. Any potential prejudice from this photograph was diminished by the judge's limiting instructions before the photograph was admitted, before the medical examiner testified, and during his final charge for the jury not to be swayed.
Could
Yes,
you tell
Justice
me what the relevance of it was, though?
Yes, Your Honor. So the relevance was the trajectory of the bullet.
Was that in dispute?
It was in dispute when the defense attorney was questioning Sergeant Detective Daly, who testified before the medical examiner, and the defense attorney was questioning him about a ricochet mark on the wall and what could have happened to the bullet. And in questioning Sergeant Detective Daly, the defense attorney specifically asked, "Do you know what the trajectory of the bullet was?" To which Sergeant Detective Daly said, "No, I'm not. I know generally, but I don't know specifically." So this picture with the probe in it went directly to that point to show the trajectory. And even more than that,
I'm confused. Who was the defense counsel? They were worried about that the bullet was deformed. I read the question. I'm just not sure what were they getting at with that?
I don't know, Your Honor. Whether the bullet was deformed going through the skull or the ricochet, I'm not sure. But it was still a question brought up before the medical examiner and then was able to be clarified through the medical examiner. And the prosecutor even said at sidebar, and he explained why he was using the photograph with the probe versus the photograph of the entrance and the exit wounds. So that the probe was less gruesome than the alternative photos, which the trial judge agreed and was not objected to. And turning to the next issue about whether or not Officer Diaz was properly allowed to testify, this was pure impeachment testimony that only came in for that limited purpose. This Officer Diaz overheard the conversations by Patricia Ross and what she was saying about changing her testimony. And this was particularly relevant to determine Patricia Ross's testimony because she was trying to ingratiate herself with the defendant throughout her entire testimony. So by being able to explain what he heard in that conversation, it was important for the jury to hear that to judge their credibility. And it was not error to admit his testimony. And lastly, the trial judge's decision not to voir dire Patricia Ross was not an abuse of discretion. This was, the defense attorney made no proffer as to what relevance of voir dire would bring. This witness had already testified and really did not have much more to add. So his denial of that request was not an abuse of discretion. And finally, this court should decline to exercise its powers under 33E because of the facts presented to the jury do not raise any issues or any substantial likelihood of a miscarriage of justice. If there's no further questions.
I have one. Do you want to, given the sort of tense relationship between defense counsel and the judge, do you have anything to say about why that didn't impact the conduct of the trial, or just leave us to reading all the transcripts on that?
Sure. Well, I would largely rely on the transcripts because they, notwithstanding the defense attorney's reaction to the seating of juror number 35 on the second day and his speech to the judge, if you will, nowhere else in the transcript does the defense attorney reference that incident or reference that he's unable to concentrate on the trial or he's unable to perform his duties. And at the point where we're at now, if you're to look at that without any affidavits from trial counsel or any evidentiary hearing in the lower court, there's not much to be made of that. So I would rely on the transcripts.
And he was not held in contempt until after the trial, right?
He was held in contempt during the trial. Sentencing was held over until after.
There was no indication what the sentence would be prior?
No, that's correct. There was no discussion about that until after the trial.
Okay, thank you.
And if there's no further questions, Commonwealth will rest on its brief.
Thank you, Mr. Armstrong. Thank you, counsel.
Thank you.
Your honors.